Welcome to today's presentation. My name is Alice Hogue and I'll be your instructor. Today we're talking about running the chain of title. And as many of you know, chaining title or running title is one of the most critical skills required of a landman. So what we'll do in this session is we will review the process and the purpose of chaining title, recognizing that the ultimate goal here is that we want to identify who the correct mineral owner is so that we can lease that landowner. We can find out who is open of record, quote unquote, so that we can lease that landowner and know that we have the correct owner. So let's look at what our topics will cover today. And we'll start with a review. We're going to start with a little bit of a review from Module 1. There are just some terms that I think you need to understand before you can really understand chain of title. And I know not all of our students saw those webinars in Module 1. So we're going to go over those review items. We're going to talk about the difference between real property and personal property. We're going to talk about statute of frauds and recordation laws. And then from there, we'll give you an overview of chaining title. I'm going to tell you how you record a document in the county courthouse. And then I'll give you just a typical chain of title, what we're talking about when we're talking about a chain of title or tracing these conveyance instruments. And we'll talk about what it means to start with from the sovereignty, to trace title back to the sovereignty. We'll talk about what's called letters patent. And then we'll look at the distinction between the surface estate and the mineral estate. We'll talk about how there can actually be a different owner for the surface and a different owner for the minerals. And we'll talk about the laws that apply in that case. That is, we'll talk about the dominant mineral estate. And then from that point, I'm going to give you just a couple of examples of how title is chained and where you need to go to find the information that you need so that you can identify the correct owner. And then we're going to go over how the process works. Geology gives land a map. Land then has to go to the county records and find the documents. And from there, we're going to walk you through the 10 steps to running title. We talk about preparing to run for title. We talked about actual running for title. And I'll walk you through each of those steps, how you go to an abstract company to get information. And then we'll wrap up with final notes and a conclusion. So let's begin with our review from Module 1. In Module 1, we talked about the distinction between real property and personal property. And we said that the law classifies properties in two ways, either as real or as personal. If it's real property, what we're talking about is the land. You remember the term real estate. That's sort of the same thing. Real estate, real property. Okay. Initially, the designation was to differentiate between the land and the chattel, the land and the livestock on the land. So land and chattels became real property and personal property. Now, in Louisiana, we call this immovable property and movable property. So in Louisiana, if something is deemed immovable, it is considered real property. If it is movable, things like your car, your watch, your jewelry, artwork, your furniture, washer and dryer, those are the things that you can physically possess and take with you. Unlike land, the only way you can show ownership of land is to actually live on that land or to have a document filed of record saying that you are the owner of the land. You can live on it or you can farm on it or have a document saying that you are the owner of the property. Land is not something that you can pick up and take with you. So land is considered immovable property. It is considered real property, whereas chattels or your watch or your car are considered movable in Louisiana, or what we call personal property in Texas and most other states. Now, in Louisiana, there was a famous Louisiana Supreme Court case where this couple owned this house on St. Charles Avenue in New Orleans, Louisiana. And while they owned the house, they installed this beautiful chandelier in the house. And when it came time to move, they sold their house, but then they wanted to take the chandelier with them. Well, it wasn't stated anywhere in the closing documents that the chandelier would stay or would go with the couple. So there was a big Louisiana Supreme Court case where the couple that owned the house that was selling it said, this is movable property because we can physically unscrew this chandelier and take it with us. And the couple that bought the home was saying, no, it's immovable property, even though you can physically remove it and take it away, because it is affixed to the property, because it is a part of the property, it is considered immovable property, and therefore you cannot take it with it. So what you look at then is it something that is affixed to the land? So for example, if it's something that can't be removed without substantial damage, you could say a chandelier, you could say a door, you could say a bathtub, a toilet. Those are the kind of things that are considered part of the real property. They are real property because you cannot move them without causing substantial damage. So why is this relevant to our study of oil and gas? Well, it's relevant because oil and gas is considered real property. Even though you can physically drill it and take it away, when it is in the ground, it is considered real property, immovable property. And the significance is that if it's real property, it's got to be recorded to be binding against third parties. So anytime we're dealing with the sale or the conveyance or the mortgage or the lease of real property, of oil and gas on the land, those documents need to be recorded to be binding against third parties. Now, if we're talking about personal property, if you sell something on eBay, for example, there's no recording required for personal property. So that's the major distinction for our purposes, is that if it's considered real property or real estate, it's got to be recorded to be binding against third parties. And I'll show you what I mean as an example. So what happened was there was in England, this all started with the Statute of Frauds. The Statute of Frauds is a doctrine or a law that was originated in England in the 1600s, and it was designed to stop the numerous frauds that were being perpetrated against the court. You see, back then, all that was necessary in order to transfer property was there was a formal ceremony, and the person that owned the property would bring a twig or a branch or a leaf from that property. There would be a formal conveyance where the person that owned the property would give the lease or deliver the leaf or the twig or the branch or whatever it was, deliver that to the new owner, and that was how the new owner became the process owner. Well, what happened then was courts became clogged with everybody holding their leaf or their stick or their branch or whatever it was and saying, I'm the owner of the property. And the other person would say, no, I'm the owner of the property. I have the stick. I have the leaf. I had the branch. So it became impossible for courts to determine who actually owned the property based on who had the twig. So they said, enough is enough. We are going to enact a statute that says anytime you're dealing with an interest in real property, okay, it's got to be in writing. So there's no oral contracts when we're talking about real property. Under the Statute of Frauds, which is still in effect today, if we're dealing with real property, it's got to be in writing, okay? And it's got to be signed by the transferor. That is, the current owner has to sign it to the new owner, conveying the property to the new owner, okay? Now, we can also have this new owner's signature on it. That's no problem. That person is known as the transferee. There's no problem with having them both sign it, but at a bare minimum, the transferor has to sign the document. And so therefore, they put away all this chaos that was caused by all these people holding these sticks and branches. And so now today, you cannot have an oral agreement to lease someone's property. It's got to be in writing under the Statute of Frauds. So what happened next was courts became clogged with people holding their piece of paper. Well, under the Statute of Frauds, I own the property because I have the writing. And another person would say, well, I also have an original writing that has your signature on it that says I own the property. No, I never signed that, et cetera, back and forth. So the court said again, enough. What we're going to do from now on is we're going to say that it's got to be recorded in the county records to be binding against third parties. So if we have a conveyance of real property, talking about conveyances now, a conveyance of real property, it's got to be recorded in the county records. Now, as a general rule, the first person that records the lease becomes the owner of the property. So if I own property, let's say I own property in Louisiana, and an oil and gas comes up to me, oil and gas company comes up to me and says, we want to lease your property. And I say to them, sure, and they're going to give me a huge bonus and a huge royalty, so I sign a document with B. Then another company approaches me, C approaches me and says, hey, we would also like to lease this property from you. And I don't say anything to C, and I just say, sure. So I get that same bonus and that same or even maybe a higher royalty payment. C then records the oil and gas lease first. Who owns the oil and gas lease? And the answer is C. Even though I signed that lease with B first, because C recorded first, C is the owner of the oil and gas lease. Now look, I still have a cause of action against B because, or B has a cause of action against me because I breached the contract with B. But whatever damages B is going to get as a result of the breach of contract is going to pale in comparison to the millions of dollars that C is going to make because C is the owner of the land. So that's why recordation is important. Now, in most states, the general rule is the first person to the courthouse wins. So that's why there's always this great rush once you get the lease to get that recorded. So the first person to record wins. Okay, that is what is called a pure race state. Whoever gets there first is the owner of the property. Now there's other states, and Louisiana is a state like this. Now there's other states that are called race notice states. And in a race notice state, if I had told C, well, C, I'm happy to lease from you, but I actually already leased from B, and C says, I don't care, let's just go ahead and do it, and C files of record first, he cannot take advantage of being the first to record because he had notice that there was another lease. So that's what the race notice statute says, or the race notice states. If C had prior knowledge that there was already a lease on there, even if C records first, he won't be the winner. Now, you can imagine this is going to be a lawsuit. And the lawsuit is going to say, well, C is going to say, well, I didn't know. A didn't tell me anything. And A is going to say, I told him, or I thought I told him. And anyway, it's going to be a big mess. But the bottom line is, be the first person to record it. Then you won't have to worry about it. You know, if you're aware of a situation where there is notice, just recognize that you may not actually be the owner of the lease. Okay, so that is what recordation is about. And so now the first person to record is the owner of the property or is the owner of the lease. So that's statute of frauds and recordation. Now that concludes our review of Module 1, but I do want to tell you how you record a document. So as we said, to show ownership of real property, we have to file a document or an instrument in the county clerk's office where the property is located. Okay, this is filed where the property is located. So if someone lives in Florida and they own property in Oklahoma, and the Florida person sells their Oklahoma property but records it in Oklahoma, that is not a valid recordation. It's got to be where the property is. Okay, and just think about it. If that document is filed in Florida and someone's tracing title in Oklahoma, they're never going to find that Florida deed. So it doesn't make any sense to file it where the person lives. It has to be recorded where the property is. So to record a document, what you do is you either go to the county seat where the property is located and where the county clerk's office is located, and you find out where the deed of records are or the public records are, and you go to that clerk's office and you say, I want to file this document of record. And the county, and there's usually a charge for this. It's a small fee, but like in Travis County, I think it's $16 for the first page and then $4 for each additional page. And then if you want a certified copy, certified copies are $5 each. Or you can just mail your document to the clerk of court and ask them to record that document for you. Now, what we used to do in the old days, and I don't know if this is done so much anymore because of images and things being digitally imaged, but we would take 2 original leases. So we'd have that landowner physically sign 2 identical leases. And so when we would go to record it, we would give both copies, or both originals rather, to the county clerk. She would stamp both copies, keep a copy for her files, and then you had an original stamped copy for your land records or for your lease records. In this age of digital imaging, I'm not sure that's so important anymore, but it's a good way to track, exactly the documents that you have and what the volume and page is, in case there's any kind of dispute. Okay, so now let's look at an overview of running title. When we talk about running title, all we're doing is saying the recorded history of owners of a certain parcel of land or minerals, and all it's showing is the transfer of the interest from one person to another. We call it a chain of title. Imagine these are chain links. And so it's the chain that links the first owner, which is the U.S. government, to person A. And then there's a link which links person A to person B. All it is referring to the links of title documents. And they typically start with what's called letters patent. Sometimes you'll hear this said, we're going to chain title all the way back to sovereignty. Well, the sovereign is the United States government. At one time, the United States government owned all the property. And we talked about that last time. And one way they were going to pay for the debt from the American Revolutionary War is they were going to start selling land. So that's when all this started. They were going to start selling the land that the federal government owned, and they would sell it to individual people in something called letters patent. That was the name of the document that they used to transfer the interest. Now, if you look up the term patent in the dictionary, it's defined as a government grant to an inventor of the right to exclude others from making, using, or selling an invention. In the same way, a patent is used to secure land. It is a government grant to a landowner of the right to exclude others from making or selling a given piece of property. So that's what letters patent is. And if you go all the way back to the first document in the chain of title, you will run across what's called letters patent. I happen to have the letters patent from my grandmother's grandfather, so what's that, my great-great-grandfather, conveying property in New Orleans, Louisiana, or rather it was at the General Land Office in New Orleans, Louisiana. And you can see clearly it says the United States of America. It has a certain homestead certificate number, application number, and it just says, whereas there has been deposited in the General Land Office of the United States a certificate of register at New Orleans, Louisiana, whereby it appears that pursuant to the Act of Congress dated May 20th, 1862, quote, to secure homesteads to actual letters on the public domain, the claim of William Stoddard, my great-great-grandfather, has been established and duly consummated in conformity to law for the, and then it gives the property description, northeast quarter, the southwest quarter. According to the official plat of the survey of said land, returned to the General Land Office. Now know ye that there is therefore granted by the United States unto the said William Stoddard the tract of land above described. And then it goes on to say, in testimony whereof I, Grover Cleveland, President of the United States, have caused these letters to be made patent. And that's why they're called letters patent. Now, I don't think this is Grover Cleveland's actual signature, but he was the president at the time. And then it also gives the recording information down here, volume 9, page 344, okay? All right, so that's what letters patent is, all right? Now, just to make this more interesting, you can have different ownership of the surface and of the minerals. And if someone who owns the surface of the minerals, who owns a fee simple or a fee simple absolute, that means you own the surface plus the minerals, if someone that owns a fee simple absolute decides to sever their interest and, let's say, keep the surface and convey the minerals, or more likely convey the surface and keep the minerals. All right. So that means one person, owner A, owns the minerals, and another person owns the surface. This is probably typical. This is how my house is set up where I live. I own the surface of the land, but I don't own the minerals. I'm not sure who owns the minerals to my property, but I know it's not me. So in that case, we've created, instead of a fee simple, we've created two separate estates. One is called the surface estate, and the other is called the mineral estate. Okay, so they can each be owned by different people. So the surface estate is basically what you see. The surface can be farmed, it can be ranched, it can be subdivided, or it can be used for recreation. The minerals, though, are all the property below the surface, and it includes oil and gas, but it also includes things like sulfur, uranium, coal, copper, etc. Now, the mineral estate does not, however, include water rights. The water rights belong to the surface owner. So that's an important thing to keep in mind when we're drilling for oil and gas. So let's say an oil and gas company approaches owner A and says, hey, we'd like to lease your minerals. And owner A signs a lease with this oil company. And the oil company starts building their roads and tearing down the trees and doing everything they need to do so they can build this oil rig. All right. Can the surface owner refuse to allow the oil company to come onto the property? And the answer is they cannot. And the reason they cannot is because there is something called the dominant mineral estate. And what this says, it's a law that says when there are two different ownerships, one person owns the surface and one person owns the minerals, the mineral estate is dominant. So the mineral estate has the right to use as much as the surface estate as is reasonably necessary to convey their interest. So now, whether we pay these people or not is another issue. Under the law, we don't have to unless there's a statutory requirement, like in Oklahoma, there's a statutory Surface Damages Act, but we don't have to do that. Now, we do because we don't want the surface owner to call 60 Minutes and we're having to explain, well, you understand, Anderson Cooper, this is the dominant mineral estate. Under the dominant mineral estate, we have the right to use the surface. No, we're trying to keep on good terms with that surface owner because we are using their surface and we want them to realize that this is an ongoing relationship. So we don't want to alienate them or make them mad in any way. So we usually will pay the surface owner even though we don't have to. Now, for purposes of this presentation, if you have a different surface owner and a different mineral owners, you're going to have to run title separately. The minerals will be separated. So let me just show you a typical chain of title. I've kind of just made this up. But let's start with my great-great-grandfather, William Stoddard, and let's say he owned fee simple, which he did, from the sovereign. They granted fee simple absolute to him, so he owned the surface and the minerals. When he died, he leaves 4 children, and his property passes to his children in equal amounts. Let's say he left a will. And so Peter gets 25%, Luke gets 25%, John gets 25%, and Laura, my grandmother, gets 25%. All right. So what happens then is Peter decides, well, he's going to convey his 25% interest to Reagan. And then Reagan's going to convey that same 25% to Bush. And Bush can then convey that same 25% to Lincoln. And Lincoln's going to own, get that 25%. So if we did the property at this point, the ownership would be Kennedy 25%, Luke 25%, John 25%, and Laura 25%. But let's say Luke also gets into a jam and he needs to get some money. So he sells his 25% interest to Ford, who sells it to Ike, who sells it to Washington. Now the ownership at this point is going to be Kennedy 25%, surface and minerals, Washington 25%, surface and minerals, John 25%, and Laura 24%. Now let's look at what happens if the minerals are severed from the surface interest. So in this case, Peter has 25% ownership in the surface and the minerals. He conveys all of his 25% interest in the surface to Kennedy. Okay, and he conveys half of his minerals to Carter and half of it to Reagan. So now at this point, the mineral ownership is Kennedy owns 25% of the surface, with the remaining 75% surface owners being Luke, John, and Laura. And Carter owns 12.5%, Reagan owns 12.5%, Luke owns 25, John 25, Laura 25. Now let's say Carter then conveys half of his 12.5% interest to Clinton and half to Jefferson. In that case, Clinton would own 6.25% and Jefferson would own 6.25%. So he's actually conveyed all of his 12.5% to Clinton and to Jefferson. Reagan does the same thing. Reagan conveys half of the interest to Bush and half of the interest to Lincoln. Therefore, the ownership at this point is Clinton 6.25%, Jefferson 6.25%, Bush 6.25%, and Lincoln 6.25%, with Luke, John, and Laura owning the remainder mineral interest and surface interest. So let's look at what our title opinion would look like. It would show Kennedy as we would first break it down into surface and minerals. The surface ownership is going to be owned 25% by Kennedy, 25% Luke, 25% John, and 25% Laura. The minerals are going to be owned Clinton 6.25%, Jefferson 6.25%, Bush 6.25%, Lincoln 6.25%. That makes up all of Peter's 25%. And then Luke, John, and Laura will get the remaining 25% of the minerals. So that's basically what running title is. You're basically spelling out who owns the surface and who owns the minerals. So now let's look at the process of identifying lands to be researched. In order to get to this point, you have to know where the reservoir is, where geology believes that there's oil and gas under the ground. So you may recall from last month that geology determines that there is a play. That is a place where oil and gas is found. It's a term used to describe geologically similar reservoirs or oil fields with the same source, or the same reservoir, or the same trap characteristics. Now, depending on how large the play is, that's going to determine how large the area is to consider lease acquisition. So once we've identified the play and they shoot seismic and they look at well logs and they look at other records, geology is going to give the landman a plat. And they're going to say, look, we believe that there is a reservoir under all of this land. And so go out and try to find everything that's open of record. Our company needs to have a position in this play. So typically in a map like this, in the old days, we would actually physically color in all the areas that were leased. So the white spaces then represented those areas that were open of record. So we can see right away that in Township and Range 5 North 4 West in Section 6, for example, that's all open of record. So I'm going to go and find out who the owners are in Section 6. I'm also going to go look in Section 5, and I'm going to look for the owners in the northeast quarter, the northwest quarter, and the southeast quarter here. Same thing with 4. I'm going to also find places open of record in Section 33. So now I know the legal description for the properties that I want to lease. So now how do I figure out who the owner of Section 6 is? You'll notice it's not on this map anywhere. The only way to find out who owns Section 6 is to go to the county records. So that's what our next step will be. So the problem is we've got a property description, okay? If a document is filed of record, it's filed alphabetically. It's filed under the grantor index, and it's filed under the grantee index. It is not filed according to the property description. So how in the world do you find out who owns the records if all that's in the county courthouse is a grantor-grantee indices? You don't even know who the grantor is. You don't even know who the grantee is. So what do? Well, you go to the abstract office or the county appraisal district. Now, these guys saved our life because what they do is they go to the county courthouse every day, and every document that's filed of record, they take it and they file it by property description. So in order to find out who the owner of the land is, we have to go to the abstract company. Now, what the abstract company is, as I said, they go to the county courthouse every day, and every document is recorded. They make a copy of that document, and the volume and page, it's already recorded. They make a copy of that. They bring it to their abstract office or their abstract plant, and they organize it by property description. So if I went into the abstract office, I would say, who is the owner of Section 6, 5 North, 4 West? They would take me to that part of their plant that says these are all the conveyance records for that specific piece of property. And it's a big stack. It's literally reams of paper. I mean, if you can think, half a foot long, sometimes it's longer, taller than that, but it's a lot of paper because it's every single conveyance that's in the records filed by property description. So what you do then is you go to the county, to the abstract company, and here's an example of an abstract of title that I pulled. This is abstract of titles of Ward County, Texas. So on the stack of these reams and reams of paper, it's got like this index that says every single transaction that has occurred on this property since sovereignty, since this is 1893. Okay, so you can either look at the index, or if you're a title attorney, a lot of times you'll order the entire abstract, which costs thousands of dollars. So you can either sit in this abstract plant, and by the way, they charge you by the hour for how long you want to sit in there, or you can just do a run sheet. So that's the big picture. Now let me walk you through the 10 steps then to chaining title. The first thing I want to do, once Geology hands me a plat map that says the township and range and the section on it, the first thing I want to do is I'm going to sit at my desk at my office, and I'm going to pull as much information as I can from the records that I have in my company or from computer documents. So there's a system, a software system called Dwight's PI, Dwight's Petroleum Information. And if you look on Dwight's for this section 6, it will show you all the wells that are in that section. And based on it, also show you any dry holes that were drilled in that area. So you want to know, are there any wells out there? Are those wells still producing? What is the amount of the production? Because maybe it's producing, but it's not producing in paying quantities, which means it's not going to hold a lease. So I'm going to look at those state production reports. In Texas, it's the Texas Railroad Commission, and I'm going to see how much any wells are there that are producing. And then I'm going to look at any old land maps I have. Sometimes this is an area where your company has been before, and there may be a land map that shows who the current owners are, or maybe it even has old lease numbers from your system that you can go back and say, okay, I know at one point this person owned it. So I'm going to try to do as much information as I can online from my desk. From there, I'm going to go to the county seat where the land is located. Now, this is where the records are located. Now, how do you find out where this is located? You just do a Google search, Monahans County Seat of Ward County, county seat, and it will tell you where that is located. Now, one reason that we like to hire brokers in the field or independent landmen is because a lot of times they know all this stuff. They know where the courthouse is. They'll know even who the players are. They'll know who the owners are of that property, or they may know the county clerk personally. So we like to hire brokers to go out in the field and do this work. Okay, so how do we find that abstract company? Again, I'm just going to do a Google search, abstract company, Ward County, Texas. Now, again, if you have a broker, he may know, well, Pioneer Ward County, he prefers to do business with Elliott and Waldron Abstract Company. And then it'll give them the physical location. Now you know where the abstract company is. And if I'm really on my game, I'll call that number and let them know I'm coming and ask them to reserve a space for me. Because sometimes these abstract companies can be very crowded. And they charge by the hour, so I want to be able to get in there. Now, the records are usually in these large books that start with the earliest document and end with the latest documents filed. Sometimes they have copies of the actual instruments, and sometimes they'll only have a listing by legal description of all instruments filed affecting that particular legal description. Some plan to use index cards and have a separate card for each instrument. So what I wanted to show you here is that you've got the grantor's name, the grantee's name, the description, which says all of H&ITC Survey Block 32, Section 8. And then it'll have the dates. This is the date that the instrument was signed, typically, and this is the date, the recording date. This is 1893. Okay? And then it's going to give you every document from that point on. And so what I want to do is I want to write down on my run sheet every single grantor, grantee, the kind of instrument, and the dates. And then they'll also have some notes. If they have any notes down here, I will make note of that. Here it says case filed August 18th, 1996, section 1 through 5, number 13. So I'm going to make a note of that because that means there might be a lawsuit that affected this conveyance. And then you see as you go down, they'll start getting more specific. Here they convey the west half of the north half of the north half, and you'll just go down and you'll take your run sheet. And now every landman usually has a form that they like to use for their run sheet. So when you're running title for the assignment this month, just use whatever run sheet you have. You're welcome to use this one, but or you can use whatever one you have. But note that all I'm doing here is I'm writing down the volume and the page number that's noted over here. Oh, you can't see it. Yeah, here it is. See, this is volume and page number here. So this is volume 1, page 3. Now, for purposes of this document, I started from 1935. This is the chain of title you'll run if you select option 2. But we start from 1935, and we just write down the volume, page, the instrument date, the recording date, the grantor, and the grantee. Now that's going to let us go then to the county courthouse and start pulling these volume and page numbers. So let's see. So from here, I'm going to go to the county clerk's office and I'm going to start pulling books. So let's look then at this second to last document. This is in volume 2146, page 230. I'm going to literally go and pull the books for that. And I'm going to look for the grantor, who's Charles Stow, and the grantee being Permian South. Then I'm going to pull that book, and I'm going to go to that page number, page 230. And the first thing I'm going to do is I'm going to make sure that this is a legal document. And in order to be a legal conveyance, you have to have a grantor. In this case, that's the owner. I usually use this as a crutch. The owner of the property is the grantor. And so Charles Stow and wife Chandra Stow, and they say clearly it's grantor. And then I'm going to look to make sure there's a grantee. Here's a grantee down here, Permian South 40 Partners. And then I'm going to make sure there's consideration. Consideration just means that it's a binding contract, that money was exchanged. The court doesn't care how much money was exchanged. They just care that there was consideration. And then I'm going to look at the granting clause. Now, all it needs to say is A conveys to B. But a lot of times there's more than that because we lawyers like to use a series of verbs. In this case, it's grant, convey. We might say grant, convey, sell, mortgage, lease, let, etc. All that's fine, but it's got to say at least grant or convey or A transfers to B. And then I'm going to check the legal description. I've got two separate legal descriptions here, 348 and 6973. I'm going to make sure that that's in the block that I'm looking at. Block 39, section 44. All right, then I'm going to make sure that it's signed and that it's acknowledged. I know it's recorded because it's already in the deed records. Now, when you're looking at these instruments, it's very important to distinguish what is being conveyed. Are they conveying minerals or are they conveying the royalty? Now, if they're conveying minerals, that means they're conveying the property interest under the earth. And remember, the mineral owner has the executive right. That means that's the person you approach to sign the lease. They have the right to execute that lease. They're also going to get the bonuses and the rental payments. A royalty owner does not have, this is someone that owns only a royalty interest. Okay, a royalty interest only, who does not own the minerals, only the right to a royalty. So when the oil and gas company drills and they start paying royalty, this person's either going to get all the royalty payment, or they're going to get half, or they're going to get a percentage of the royalty payment. So its definition is a right to receive a production payment. So in other words, if you are the mineral owner, you have the executive right, the bonuses, and the rentals. If you are the royalty interest owner and you own no minerals, you're only entitled to that royalty payment that's been granted to you. And a lot of times these people are known as non-participating royalty interest owners and not mineral owners. So when you're looking at the deed, you want to look at the language that's in the deed. If it uses the word minerals, then it's conveying a mineral interest. If it uses the term oil and gas in or under, then we're talking about a conveyance of minerals. If the fraction size is greater than 1/4, then we're talking about minerals. On the other hand, if it says, I convey the oil and gas produced and saved under the land, they are only letting this person have a share of the royalty payment once there is oil and gas under the ground. It would also say oil and gas produced, saved, and marketed, and usually the fraction sign is going to be less than 1/4 if we're talking about a royalty interest. It's basically going to be a portion of the 1/8 royalty, or whatever the royalty is in the lease. But all I want you to pay attention to is when you're looking at these conveyance interests, do they use the term minerals? If they use the term minerals, I'm paying attention, because that's going to tell me who the mineral owner is. If they use the word royalties or oil and gas produced and saved, I don't really care about the royalty interest owners. That's going to be for the title attorney to figure out when he does the title opinion. All I really am tracing is who owns the minerals at this point. But you'll see in some of the deeds, they'll talk about royalty or non-participating royalty. I don't want you to get hung up on that, because that's not really relevant. The person we're looking for is the mineral owner. So you need to know how to interpret those deeds. Then once you have done that, once you've run your chain of title, you're gonna chain it out. Now what I usually do is this person has used an Excel spreadsheet, and that's great. A lot of people use that. But what I usually do is I just have a legal pad, and on the legal pad I'm going to have a column for grantor, a column for grantee. Now the way I do it, I don't really have these columns. I just know, for example, in this case, it's going to be Mamie T. Joint and Ursula Noonan. I'm going to write both of those names down. So let's pretend like I wrote the whole thing, MJ and Ursula Noonan. And then I use an arrow. So I'll put an arrow, and then I'll put the names of the people that they conveyed to. Okay, and the people that they conveyed to is, Ellen Parrish and Mabel Parrish. So I'm going to write their full names, EP and MP. All right. Then I'm going to say what share of it, or what's the fraction that was conveyed. Here you'll say this is deeding an undivided 1/2 of a signer's interest in and to the minerals. So I'm going to put 1/2 mineral interest here. And then here I'm going to write down all this, deeding an undivided 1/2 of interest in and to the minerals in lots 3 and 4 in the Southwest as joint tenants, not as tenants in common. All right. Then I'm going to have a place here for the recording information and the date the instrument was signed, And over here, I'm going to have the type of deed. So I'm going to have like warranty deed, or this is actually an assignment. But that's just how, and then here I'm going to put the description. And that's how I do the chain of title. But this person, you can see, is much more sophisticated. They have the instrument name, the instrument date, the recording date, the volume. I have all that information on mine as well, but it's not an Excel spreadsheet. And what you're trying to do is you're trying to write all this information down so that you can go back and figure out who the owner of the property is. If you want to make copies of every instrument that you see, that is going to cost you about $5 a page, and it takes about 24 hours to get those documents. So you don't have time for that. You've got to be the first person to lease that oil and gas lease, and so you need to do what's called a quick and dirty run sheet. And that's what this is. It's the chain of title, and once you find out then who the current owners are based on that chain of title, then you can go and find the mineral owners. But what happens sometimes is you'll see a gap in title. You'll be going along and everything makes sense. This person conveyed to this person who conveyed to this person. All of a sudden there's a stranger to title there. In that case, you're going to have to go and check the probate records or the marriage records or the mortgages. Sometimes you'll have to check what's called lis pendens records. That means any pending lawsuits. Records to find that stranger in title. Now, some people, to do a quick and dirty chain of title, will do only a leasehold search. They'll only go and look for leases. And that's fine if it's an area that's been leased before, but if not, you know, it might be a futile search. It's not going to be as thorough as going document by document. So let me just give you an example of this stranger to title situation. And let's say that the United States conveyed to Lincoln, Adams, and Bush. Lincoln conveys his 1/3 interest to Carter. And then the next person you see in the chain of title is Clinton conveying to Reagan. And you go, wait a minute, where did Clinton come from? The last person I show is Carter. So I should have a document from Carter conveying to Clinton. I don't have that. So where did Clinton come from? To find out where Clinton came from, I'm going to have to check the probate records. Maybe Carter died and left in his will his property to Clinton. Okay, maybe there was some kind of a lawsuit. I'm going to check the lis pendens suits. Maybe there was some kind of a lawsuit and Clinton was awarded the property. Or maybe it was a marriage type situation, or the property was mortgaged. So I'm going to check all these other records to see how in the heck did Clinton get in there. So that's when you identify the gaps in title. Clinton would be known as a stranger to title. And that's just going to make you have to go look at a different set of records in the county courthouse. Now, step 9 is we prepare our ownership report. Now, this is very simple. All you're trying to convey to your to the person that hired you is you want to say who the surface estate owner is. You want to give what the gross acreage amount is. Then you're going to list that surface estate owner. Then you're going to say who the mineral owner is. And it could be more than one. You're going to list each interest owner and what their fractional interest is in the property, and then what their decimal interest is, and what their net acres are. Then you're going to look, are there any leases out there? And if there are leases, these are the people that own leases. This is the lessor name under the lease. This is their interest, their decimal interest, etc. Now, you don't have to do non-participating royalty. A lot of people do. That's when they've only been conveyed that royalty interest. But I do want to check the mortgage records and the liens records, and I do want to see if there's any unreleased oil and gas lease. And I'm just going to put my notes in here. Now, I can either submit this to my company landman, and he'll say, okay, great, go out and lease, or the company landman may have said, once you find out who the owner is, go ahead and lease it. But I'm going to prepare this because I'm going to send this in with the leases. So the land records group will know who the owners are and who the decimal interests are. It's just going to help people down the line. And it's going to help you because you're going to know the exact ownership. Remember, you're doing a bunch of these, so it's real easy to get them all confused. So like this is just for Section 39, Tract 1. Maybe there was a Tract 2, a Tract 3. You're going to have a whole a bunch of different ownership reports, and this just helps you to keep track of it. Step 10 then is you go out and you contact that mineral owner and you negotiate that oil and gas lease using the parameters that your company landman has said to you.
you know, so much of a bonus, so much of a royalty payment. And so then you actually go out and you negotiate that oil and gas lease with the current owner, and hopefully you're successful in that. Next, in the next module, we're going to talk about the oil and gas lease itself. I want you to understand every provision in that lease, and I want you to understand how you negotiate those leases, and we're going to do some lease calculations as well. So let's just take a moment now under our final notes, and we're going to look at the 10 steps that you use to chain title. You're going to first start by preparing, and that's where you sit at your desk, you look at P.I. Dwight's, you look at any other subscription information that's available online. You may look at your company's land records, any information that you can gather. Then you're going to head to the county seat and you're going to find that abstract company. Remember, we're just going to look in the internet for that, or if we've hired a broker, our broker will then head to the county seat and they'll know a good abstract company in there. We're going to go to the abstract company and we're going to give them our legal description, and they're going to give us a stack of every property, every document that's been conveyed in that specific legal description. And from there, we're just going to take their index and we're going to write our own run sheet where it says volume and page and grantor, grantee, and type of instrument, and then recording information. And then once we have that, we're going to go to the county courthouse and we're going to start pulling those books. We're going to pull the volume and we're going to look up the page number, and then we're going to interpret those instruments. And remember, what's key is, are they conveying a mineral interest or are they conveying only a royalty interest? We don't really care if they're just conveying a royalty interest. What we care about is who the mineral owner is. And then we'll actually chain title so we can figure out if there's any gaps in title, if there is any stranger to title. And at that point, we would then go to the probate records or the deed or the mortgage records or the marriage records, those kind of things. And then we prepare an ownership report for the specific legal description, and then we contact the owner at that point. So that is what we've covered in today's presentation. I started off with a review of some real property law. We talked about recordation, we talked about statute of frauds, and we talked about an overview of the process of chaining title. Remember, we start with that map from geology. We kind of told you how to record first, and then we get a map from geology, and geology determines that there's a play in a certain area, and they give us a map that has the township and range. And armed with this information, we then go to the abstract company and pull all the documents. And then we walk you through the steps to running title, which we just covered in the final notes, and that is our conclusion. I hope you've enjoyed this presentation. My name is Alice Hogue again, and this course has been provided by Land Training. Please contact us for all your training needs at www.landtraining.net.